Good afternoon, my lord, ladies and gentlemen. In some cases, good morning or even good evening to those of you joining us from a diversity of time zones and jurisdictions around the world. Indeed, we have participants from almost 40 countries amongst us on the call today, and I will confirm in due course what the total participant numbers look like. So a warm welcome to all of you joining this session on the subject of maritime arbitration in London, present and future challenges in a changing world, which we thought was particularly appropriate given the year we've just lived through. We are delighted to have received such an excellent response to this joint HFW, 20 Essex, LMAA and Reed Smith session. In association, I should add, with our friends at the London Shipping Law Centre, where Dr. Aleka Shepherd has been a supporter of it as ever, and at Maritime London. The session is, of course, thank you, Katie. The session is, of course, taking place as part of, Katie, next slide, please. The session is, of course, taking place as part of LIDW 21, the second London International Dispute Week conference, with the inaugural event having been held in 2019. I have attended a couple of the other sessions myself, and based on this and word on the virtual street, it seems to have been another very successful week, building on what was achieved in the first week back in 2019. In this regard, I'd like to thank our sponsors, whose names are on the slide you can now see on your screens. While we have all, of course, lived through quite an extraordinary period since the last LIDW in 2019, it is worth reflecting that whereas in the last shipping session, we were constrained to a total audience of 100 due to physical limitations of room capacity and the fact that it's increasingly difficult to justify the cost and indeed the carbon footprint of long-haul flying to spend a day or two or three attending a conference in London. We now have an audience where, according to the counter in front of me, is now tipping over 250 and heading towards 300. We have much greater reach now. So as we reflect on the new ways of working that everyone is talking about, we will hopefully be able to accommodate a hybrid approach to conferences moving forward, with both physical attendance, which is great for networking, but also retaining some of the remote side of things with Zoom platforms, etc., which will hopefully ensure greater coverage, inclusivity, and a reduced global footprint, which is, I think we all agree, very important. The schedule we have planned for you this afternoon, I'm sorry, I'm just checking my notes on the schedule here. The schedule we have planned for you this afternoon is that after some initial words from our chairman, Lord Hamlin of Kersey, we will hand over to our four advertised panelists, who will be introduced individually by Lord Hamlin, and then will speak on their respective topics. We will then move on to a brief Q&A session, and at some point, we understand Lord Hamlin may also share some thoughts of his own with us, but we leave him to decide as and when he'd like to do that. We are aiming to have the panelists finished by around 1:30 p.m. or shortly thereafter, to allow 15 to 20 minutes for Q&A and a closing shortly before 2. 2 o'clock is a hard deadline, and we absolutely need to be done by then. So without further ado, it is my great pleasure to now introduce our chairman for today, Lord Hamlin of Kersey, Justice of the UK Supreme Court. Lord Hamlin was, as everyone on this panel knows, and a large number of you in the audience will know, a highly respected shipping and commercial barrister who has subsequently enjoyed a meteoric rise since his elevation to the bench, moving through the courts. Lord Hamlin took silk early and moved rapidly through the ranks, as I say. He was educated at St. John's College, Oxford, which I think was also Tony Blair's old college. Lord Hamlin may be able to confirm, and subsequently at Harvard Law School, and was called to the bar in 1981. He joined Chambers 20 Essex Street in 1982 and practiced at the commercial bar from 1982 to 2008. He was appointed Queen's Counsel in 1997, an assistant recorder in 1999, and a recorder in 2020. He was elevated to the bench in November 2008, where he became a commercial court judge. And then in February 2016, he was appointed a Lord Justice of Appeal on the Appeal Court. And then the pinnacle, top of Mount Everest, became a Justice of the Supreme Court in January 2020. That's, of course, for those of you outside the jurisdiction, that is what we used to call the House of Lords, the Judicial Committee of the House of Lords. I just thought there are a few, Nick, as we used to call him then, we don't anymore, of course, but someone, an immaculate practitioner, concise, known for his very quick turnaround and his ability to get to the essence of things. A sort of silent assassin advocacy style, always very polite in court. And just to add a bit of color, just two anecdotes. I always remember one of my first cases way back in 1994-95, the British Skill, and which was about a tanker colliding with a jetty. Nick, as he then was, he was our counsel. He was a senior junior, and we were in court. Sarah Masters was his junior, and we were all convened, and the judge, Lord Hamlin, was sitting one row back where the juniors would sit, and the judge invited, I think he may already have been in line for silk, invited him to step forward and sit in the front row. But Nick declined and said he was perfectly happy where he was. And those were the days also when he was known as he had a reputation as a charismatic figure around legal London, known for his sports cars. I think it was Porsche, then Jaguar, then the Aston Martin, Lord Hamlin, if my sources inform me correctly. But I do remember that, and there is a story circulating about the days when Ken Rokerson was head of Chambers. Ken Rokerson, lately of Halliburton fame, but also famous for a lot of other things, when they were deciding how to divide expenses up between tenants. And the story, apocryphal as it may be, was that was the day you chose to arrive in a new Porsche or Jaguar or Aston Martin. But I thought that added a bit of nice color, and of course your cricket matches, etc. But without further ado, over to Lord Hamlin. We are delighted to have you with us today, sir, and over to you to take it further.
Thank you, Jonathan. I'm afraid my Aston Martin days are long over. It's a pleasure to be chairing what promises to be an interesting webinar. It's important that judges, perhaps particularly Supreme Court judges, keep in touch with issues on the ground in the commercial and maritime world, and webinars such as this provide a good opportunity to do so. We have an impressive lineup of speakers today: an arbitrator from the LMAA, a barrister from 20 Essex, and two solicitor partners from Reed Smith and HFW, who I will introduce to you before each of them speaks. We will be covering a range of maritime arbitration challenges facing the industry, including whether virtual hearings are the future, what's new in London maritime arbitration, and what legal developments are emerging from arbitrating shipping disputes in London, ending with a session on cargo misdelivery claims. We hope to have a question and answer session at the end, so do submit any questions you have using the Q&A button. We will do our best to answer them in the time we have available. Our first speaker today is Ian Gaunt. Ian is an active commercial and maritime arbitrator, and until recently president of the LMAA. In fact, so active is he that he's fitting this talk in during the luncheon adjournment of an existing arbitration. Ian will be exploring whether virtual hearings are the future, including issues of greenness.
Thank you, Lord Hamlin, for your introduction. Thank you, Jonathan, for introducing this session. My brief presentation today will be about whether virtual hearings are the future. And I should emphasize that the views I express today are my own personal views as a result of my experience, although I know some of them are shared by colleagues, but not all of them, and they're not official views of the LMAA as such. What we're talking about today is in fact one of the biggest changes which has affected the legal profession, or at least that part of the legal profession which is concerned with dispute resolution, certainly since LIDW 2019, and arguably for many decades. We are now in a very different scenario. And the question is how long this scenario is likely to last, not only in terms of the pandemic itself, but also in terms of the techniques which we have developed as a result of the pandemic. Perhaps I could just very briefly tell you something about my own experience, which perhaps qualifies me to talk about this subject. I dealt with my first semi-virtual hearing as an arbitrator in 2012, when, because of visa problems, the Chinese witnesses in a shipbuilding dispute were unable to come to London, even though the hearing had been fixed for many months, and the arbitrators had already made arrangements to come to London, in one case from China and the other case from Hong Kong. What we tried to do from the offices of the Chartered Institute of Arbitrators was to conduct the whole of the Chinese side of the arbitration remotely. And this is only 8 or 9 years ago, and I would have to say that it was a very limited success. The internet kept breaking down. The Chinese witnesses had to give evidence very late into the night. And although we eventually succeeded, it was quite a troublesome process. Since then, I've been involved in numerous semi-virtual hearings, including on the brink of the lockdown, a 4-week hearing, which involved what we would now call a virtual hearing, with 6 witnesses and 1 expert witness who gave evidence virtually. 6 of them were in fact from China, and although they had come to London, they were placed in quarantine in a hotel and gave evidence virtually from the hotel. The other expert witness gave evidence from Hong Kong, and I'd have to say that that experience was very satisfactory, although we didn't realize at that time in February last year that it was going to lead to the sort of situation which confronted us only a month later. So immediately before lockdown, there were some semi-virtual hearings. Since lockdown, I've dealt as arbitrator with 6 fully virtual hearings, 4 of those as sole arbitrator. As I could have the first slide, please. So we were, pre-COVID, already conducting quite a number of hearings virtually, frequently where it was necessary for, in international arbitrations, for witnesses to travel long distances to attend a hearing. For example, in London, we were taking their evidence virtually by what we call video conference, but increasingly reliant on internet facilities, and this was becoming more and more efficient. Even before COVID-19, the international arbitration community realized that some form of regulation or agreed protocol ought to be developed to deal with some of the pitfalls of virtual or semi-virtual hearings. And you will probably be familiar with the sole protocol, which existed pre-COVID, even though it has now very much been overtaken by subsequent events. Can I have the next slide, please? So what happened immediately after lockdown? And lockdown was really rather sudden. Immediately before lockdown in London, I and many of my colleagues were enjoying ourselves at the International Congress of Maritime Arbitrators in Rio de Janeiro, which mercifully the country was not then affected in the way it has been subsequently by COVID. And we returned to London to find ourselves a couple of days later in lockdown. So we rapidly had to decide with the volume of cases coming on, already set down for hearing, or which were on the verge of being set down for hearing, how we were going to proceed. Were we going to simply adjourn everything, kick it into long touch, not knowing how long the lockdown would last, how the pandemic would develop? And the LMAA very rapidly took a decision that it was essential, in order to enable business to move on, for the reputation of London as the leading dispute resolution centre for arbitration disputes, to develop and encourage the use of virtual hearings. Very quickly, we developed a set of guidelines for the conduct of virtual and semi-virtual hearings, and that very recently has been incorporated in the LMAA Terms 2021, which became effective from the 1st of this month, and they're now to be found in the 6th schedule. And in fact, they have been found to be very resilient. Although they were published in May last year, we've had to make very, very few changes in the light of practice since. So the result of this was a decreasing tolerance on the part of tribunals for adjournment applications. It was in some cases quite reasonable perhaps to ask for adjournments for hearings which had been set down in April or May. Solicitors were having difficulty getting into their offices, they couldn't access documents, and witnesses might have difficulty in getting to London. But as time went on and we became more familiar with the facilities which were available for conducting virtual hearings, we became less and less tolerant of long adjournment applications, and warned parties that if they did have an adjournment, that they could expect that when the hearing date was reset, that we would probably not tolerate an adjournment simply on the basis that they wanted a fully physical hearing. Could I have the next slide, please? Well, what are the perceived advantages? Lord Hamlin and Jonathan Webb have already referred to probably the primary one, that is of cost and convenience for tribunals and witnesses. In international arbitration, where witnesses and tribunal members may have to travel very long distances internationally to attend hearings, cost and convenience become extremely important. There are also visa issues which affect witnesses in many jurisdictions, not least China. And thirdly, I would mention the concept of greenness. So this is not being namby-pamby about things, but we all have, as the shipping industry as a whole have, a duty to contribute to sustainable development. And it does open a focus on the way in which we've conducted arbitrations, perhaps a little profligately in the past. Well, I'll move on to greenness, or I'll come back to greenness shortly. But if I could have the next slide, please. I just mentioned some of the perceived disadvantages. These have been brought up in a number of contexts, and quite recently I was involved in coaching a team in the Viz international mooting competition, where one of the procedural issues which the students had to deal with was the question of whether the tribunal should order a virtual hearing or not. And the question was posed and the scenario developed at a time when virtual hearings were probably still in their infancy, and therefore the arguments pro and con seemed to be perhaps more evenly balanced. But as time went on, and as I heard the students' arguments probably 10 to 15 times, it became apparent that it was more and more difficult for the parties who wanted to abandon the hearing and wanted to kick the arbitration into the long grass and wanted to avoid a virtual hearing to make their case. But the disadvantages which do come up and are still articulated from time to time are difficulties of cross-examination of witnesses. I remember in one of the early discussions on this subject, an American lawyer in a discussion at the LIDC was very adamant that you could not properly cross-examine witnesses in virtual hearings. My experience of this is that that argument is nonsense. We are not trained as psychologists, and therefore to observe the minutest behavioral reactions of witnesses. We have a very good opportunity to see the head and shoulders of witnesses in virtual hearings, and in my view it is perfectly satisfactory for witnesses to be cross-examined by counsel virtually, and counsel being supported virtually by his solicitor's team or by an expert, although that requires perhaps a refinement of the technology. Different time zones. Well, we have to be accommodating towards this. If, for example, as in my current hearing, 6 of the witnesses are giving evidence from Hong Kong or the People's Republic of China, we have to sit early. We should be perfectly prepared to sit at 8 o'clock in the morning in order to accommodate a time difference of 7 hours, and to finish early if necessary, that is in London terms, to make sure that witnesses are not put under pressure giving evidence late into the night. We can have Zoom fatigue. I think everybody in this audience will have suffered from this to a greater or lesser extent during the last 12 months. Sitting in front of a screen requires much more concentration and is more tiring than sitting in a physical hearing. But we can deal with this by having longer breaks and having perhaps shorter hearing sessions. And that has not, in my experience, interfered significantly with the length of hearings or the time for which they need to be set down. There have been problems dealing with electronic documents, particularly in the early stages where many of the documents which had been prepared in anticipation of a hearing were probably in hard copy format. But here we're probably just accelerating a tendency which had already started before, that many of the documents in hearings, whether they were physical or virtual hearings, were in fact prepared electronically. They were probably generated electronically in the first place, and they are made available by uploading to an electronic platform, which may well also be used for the process of disclosure. So we are becoming more and more adept at dealing with electronic documents, including arbitrators who have now learned techniques to annotate electronic documents for the purposes of accessing their notes, for the purposes of writing an award. Communication within parties' teams, that can be perhaps slightly more difficult than in a physical context, but with WhatsApp groups and offline communication facilities, then communication between counsel and his experts, or his or her experts, I should say, or with the instructing solicitors can be facilitated. One argument which I've heard perhaps most frequently articulated is, well, all this is all very well, but we don't have the sort of opportunities at the coffee break or whatever it is to propose a settlement or to talk informally about the case. That may be true, but you can certainly have discussions, quite informal discussions online. And I must say that I think this argument is somewhat overplayed. Could I have the next slide, please? Challenges. Well, could arbitration awards published after virtual hearings be successfully challenged? In an international context, this is principally brings into play Article 5 of the New York Convention. And I think personally, it would be extremely difficult that if a virtual hearing is properly arranged, giving both parties the reasonable opportunity to present their cases, that any real challenge could be mounted successfully under the New York Convention. I've heard arguments about witness tampering. Well, witness tampering can occur in physical hearings outside the hearing room. We've developed techniques, including in our 6th schedule, to make sure that witnesses are not prompted in the course of a hearing, that they are asked to give us a view of the room that they're giving witness evidence from. And again, in my view, this is very much overplayed. Confidentiality, well, within the context of maritime arbitrations, I suggest that this is seldom going to be a problem to maintain the degree of confidentiality which we would be able to observe in a physical hearing. And equality of arms, well, the technology is relatively easily available and relatively cheap. Even if you have to involve a third-party manager to facilitate the hearing, it is not an expensive process, but it can add greatly to the efficiency. Now, against this, we have, could I have the next slide, please? Before I get on to greenness, perhaps I could mention something which came up in the last 2, if not 3 weeks, which was a declaration by the bars of England and Wales, of Scotland, Northern Ireland, and the Republic of Ireland, which constituted something of a backlash against the idea of going back to virtual hearings after the, or continuing with virtual hearings after the pandemic had ceased. And they said, amongst other things in their argument, experience shows that judicial interaction is different and less satisfactory in remote hearings, that the management of witnesses, especially in cross-examination, is far less satisfactory. We are concerned that remote hearings present very considerable challenges to effective advocacy. The diverse and complex needs of our clients must be protected and their participation must be safeguarded. Training experience has been negatively affected. And they suggest that effectively remote hearings should be confined very largely to procedural hearings. Well, I disagree with all of that. It may well be that those arguments have some force in the context of criminal hearings, where open justice is perhaps a more significant factor. But in the context of international commercial arbitrations, I do not think that these arguments in most cases hold water. We are able, by using the technologies which have been developed and enhanced during the course of the pandemic, to hold very effective virtual hearings which overcome all the problems which have been articulated in this joint declaration by the bar. And I wonder indeed whether that really represents the view of the commercial bar. Just turning then to greenness, it's, I think, interesting to see this in statistical terms. If you look at the kilograms of CO2 which are emitted per head in a 12-day conference, and these statistics were actually prepared for, not for an arbitration hearing, but for a typical sort of trade conference, professional conference. In the case of a physical hearing, and this is per head, it doesn't depend on the number of people, 2,961 kilograms would be emitted per head of attendees, taking account of travel and hotels and so on, against 36 kilograms in the case of a virtual conference. Can I have the next slide, please? Breaks down a little bit further these figures, which were actually prepared by the well-known Tim Berners-Lee of internet fame in connection with an international conference, and these results were published in the Financial Times. So how are these broken down? Flights, 2,300 against the Home Office, 30. Accommodation, 360 for witnesses and counsel who may need hotel accommodation. The CO2 emissions regarded as inherent in the manufacture of the computers which are used is 5. Local transport, 200. Use of networks and data centers, 1. And that's not counting the cost of the paper which is used if we're not able to move to electronic documents. So I think that's a fairly convincing argument in favor of the economic and sustainability credentials of virtual hearings. Could I have the next slide, please? Well, in conclusion, therefore, are virtual hearings the future? In my view, semi-virtual hearings, definitely. There can be no argument about that. There is no justification for flying witnesses halfway across the world to give 15 minutes of evidence in cross-examination. Fully virtual hearings, these seem to be less popular. And if you take the survey conducted by White and Case and Queen Mary University of London, which was published last week or the week before, they say that only 8% of their survey participants wanted fully virtual hearings after the pandemic restrictions had been lifted, whereas something like 45% were very much in favor of semi-virtual hearings. And definitely for procedural hearings, in all cases, there can be no justification for physical CMCs and procedural hearings. Will we have perhaps a move towards more documents-only decisions? Perhaps that may be the case. There seems to have been perhaps some reduction in the number of hearings, including semi-virtual or fully virtual hearings during the pandemic. It may be that people are looking more critically at the value of witness evidence, and that's perhaps apparent in the new rules which have been adopted by the Commercial Court, and also by the criticisms which have been made of the use and assessment of the value of witness evidence recently in a report by the ICC. But in LMAA arbitrations, I think it's important to understand this, that already 80% of awards issued by the LMAA, that's 500 awards a year, or 400 out of the 500 awards issued each year, are on documents only. And so no form of hearing is required at all. But it may be that parties will look more critically at how far they really need the cross-examination of witness evidence, or at any rate the length of hearings which we've become used to. So could I have the next slide, please? No, we don't have any more slides. So this is the point at which I hand back to Lord Hamlin and to Karen Maxwell. So thank you very much indeed for your time and participation, and I hope to see you virtually or semi-virtually in a hearing soon. Thank you.
Thank you, Ian. The future of virtual hearings is a matter which the courts are also giving close consideration to. In the courts, I can see there being some use of virtual hearings and of hybrid hearings, especially where there are significant savings in cost and convenience. In the Supreme Court, we've been operating remotely since lockdown in March last year, and it has been remarkably seamless. In fact, no Supreme Court case had to be adjourned due to lockdown. We were fortunate in that all the documentation was already required to be filed electronically, and we also do not have the complication of witnesses. That said, I look forward to getting back to in-person hearings, which is planned for next month. Oral advocacy is an important strength of arbitration and litigation in London, and my own view is that its full benefits are not realised remotely. There is a loss of immediacy and of the natural interplay between the tribunal and the parties' representatives, and indeed between the members of the tribunal themselves. So I'm less of a complete enthusiast for remote hearings than perhaps Ian is. Now, our next speaker is Karen Maxwell, a barrister at my former chambers 20 Essex, who specialises in shipping law and arbitration. She's the co-author of Ambrose, Maxwell and Collett on London Maritime Arbitration. I was in fact Karen's pupil supervisor in chambers many moons ago, and so I can personally vouch for her excellence as a speaker. Today, she will give her view of what's new in London Maritime Arbitration.
Thank you. Thank you very much. And can I start by thanking the organisers and hosts for inviting me to participate today. Could we go on to the first slide, please? So I'm going to try today to identify a few areas where users of maritime arbitration might think there is some room for change or improvement. And actually 2021 is quite a good time to take stock because we have a big birthday this year. It's the 25-year anniversary of the 96 Act, and the Law Commission is currently consulting on the question of whether the time has come to make amendments to the Act. It's quite interesting to see how they frame their inquiry, that they're looking to ensure that the UK remains at the forefront of dispute resolution. So they're approaching this question with the users of arbitration very much in mind. Could we go to the next slide, please? And just to quickly sketch in a little bit of background. And really the headline here is that maritime arbitration in London remains incredibly popular and successful. The statistics show that notwithstanding the pandemic, 2020 was actually a record-breaking year for the LMAA and actually also for the LCIA. The Commercial Court also reported that it was operating at full capacity in 2020. But interestingly, award challenges seem to be continuing their downward trend. It's possible that that may reflect satisfaction with arbitration and with awards. Perhaps more realistically, it reflects an understanding that it's actually very difficult successfully to challenge an award. So if we move on to the next slide, and that brings me to my first topic, and it's one of the topics that the Law Commission has identified for possible review. And it is the question of whether we should now make it easier to appeal. Now, we know that there are very few applications for permission to appeal, and we think that permission is probably granted only in around 30% of those applications. So that raises what I suppose in some ways is a bit of an old chestnut, and it's the question of whether the popularity of arbitration is actually stifling the development of English law. All I want to do today is highlight two recent developments that I think should form part of that discussion. The first is that it seems to be becoming more common for judges to reformulate or perhaps refine the questions of law at the permission stage. I've certainly had a recent case myself in which that happened, and we've got another recent example in the CVLC3 decision. I don't think there's anything objectionable in principle at all about this happening, and it might provide one limited way in which the court can ensure that focus is on interesting or useful questions. It does raise a potential wrinkle, though, in that there's a potential for an argument then that the reformulated question wasn't one that the arbitrator was asked to determine, and that's one of the Section 69 criteria. That argument actually came up in CVLC3, and Mrs. Justice Cockerell adopted quite a robust approach. She said that it was sufficient to show that the reformulated question was inherent in the issues that had been raised in the dispute. So I think greater judicial involvement in defining or perhaps refining the questions might ensure that appeals focus on issues of general importance and could therefore provide some assistance in developing the law. My second point, I think, is a more significant one, and it's really the greater use of Section 45. Now, Section 45 is the provision that allows a court to determine a question of law rather than the tribunal. But to use Section 45, you have to jump through a number of hoops. You have to show that the question substantially affects the rights of the parties, and you need either the agreement of the parties or the permission of the tribunal, plus substantial saving in costs, and you have to show there's been no delay in your application. Now, historically, this has been very much a neglected provision, but I think recently parties seem to be making better use of it. And actually, one good example of really effective use of the provision is the eternal bliss, which Nick Austin is going to talk about shortly. So I won't say anything more about that now, but it does seem to be a potentially useful avenue to get questions of law before the court. And then that raises, in my mind, a further question. If we do want further questions of law to get to court, should we think about liberalising Section 45? For example, would it be right to allow an application simply on the basis of tribunal permission without having to jump through any further hoops? Well, I'll leave that question hanging there because I'm sure we'll all have different views about it. So if we move to the next slide, and this is another topic identified by the Law Commission, and it's whether we should change the procedure for jurisdictional challenges to awards. So at the moment, a jurisdictional challenge takes the form of a complete rehearing. So there are really two key objections, I think, to that. The first is that it's very wasteful. I've given on the slide the example of the pounder. That was a case in which the tribunal heard witness evidence on a jurisdiction challenge, and then the court heard the same witness evidence, plus I think also some additional witness evidence and some further disclosure. So you can see straight away that that's incredibly inefficient. The second drawback, I think, is also illustrated by the pounder, and that is, in that case, the court took a very different view of the witnesses to the tribunal. And that, I think, inevitably leads one to suspect that witnesses might be able to polish or to finesse their evidence in light of the cross-examination they have undergone in an arbitration. Again, we have a somewhat neglected provision in this area. It's section 32, and that allows the court to rule in the first instance on issues of jurisdiction. So it's the jurisdictional equivalent, if you like, of section 45. It has very similar but not identical requirements to section 45. And so I think a similar question arises here. Should we liberalise this provision or tweak it to allow or to encourage earlier court intervention with a view to avoiding inefficiency? Well, if we move on to the next slide now, and a completely new topic, bias and the duty of disclosure. So of course, we've had the Halliburton decision this year, and that's clarified the law on the duty of disclosure in the context of multiple appointments. I just want to touch on two questions that I think are not answered by that case. The first is whether section 24 needs to be amended. Now, some commentators, in particular Louis Flannery, have argued that if you have established a breach of the duty of disclosure, there should then be a presumption of bias, and the onus should be on the arbitrator to displace that presumption. And he's argued very strongly that section 24 should be amended to introduce this sort of mechanism. So it may be that that would form part of any review of the Act that takes place. Just by way of brief comment, I mean, I have to say I don't see that this would necessarily be very impactful on the outcome of cases, because it seems to me they turn really not on the burden of proof, but more on a qualitative judgment of all the circumstances. But there we are. That's a debate that's sort of rumbling on and may arise in any review. The second point I've raised is very relevant to maritime arbitration. So the LMAA intervened in Halliburton, and they adduced it was unchallenged evidence actually, that it was very common to have multiple appointments. This wasn't perceived as problematic, and it was understood that no disclosure of those appointments was required. And the Supreme Court analysed this as a sort of implied agreement arising from custom that would exclude the need for any disclosure. But at the same time, they gave a pretty strong steer that it's probably preferable to amend arbitration rules to make this clear and transparent. And I believe that the LMAA are currently thinking about this. I think I just really wanted to flag up one potential point of principle here. The Supreme Court say that the duty of disclosure is based, at least in part, on section 33, the tribunal's mandatory duties. So to my mind, the question that arises is whether it is possible, in fact, to amend rules so as to cut down any duties of disclosure that otherwise would have arisen under section 33. And the reason I say that is that section 33 is mandatory, and the DAC tell us that any agreement to dispense with it would be unenforceable. And that particular aspect, I think, is not addressed in Halliburton, but to my mind would be something to be aware of. So moving on then to the next slide, and a new topic, section 44 and third parties. So section 44 is the provision that allows the court to make supportive orders, including in particular freezing injunctions. So it's a really useful tool for users of arbitration. Now, in court proceedings, you can in some cases get a freezing injunction against a third party under the so-called Chabra jurisdiction. In arbitration, unfortunately, the position is a little bit messier, and that's because the wording of section 44 has driven the courts to conclude that a Chabra injunction is not available in support of arbitration. And alongside that, there are some parallel issues relating to whether it's possible to establish a jurisdictional gateway for service out, given the way that the provisions are worded. And then on top of that, we now have the decision of the Court of Appeal in the A and B case, and they have held that you can make an order for the taking of evidence by way of deposition against a third party effectively under a different part of section 44. So on its face, there's some inconsistency there. I think that inconsistency has been driven by the wording of the provision. So it does seem to me that there's probably quite a strong argument for trying to amend section 44 to bring it into line with the position in court, so that in appropriate cases, you could get relief against third parties. So if we move to the next slide, please. And this is my final point. It's one around procedure, so it's probably one for practitioners rather than users. And it relates to witness evidence. As Ian mentioned, in court proceedings, we've got a new practice direction which sets out much stricter rules about the content of witness statements. And the headline really is that they are to contain evidence and not legal argument. Now, it's clear from the consultation documents that this direction is intended to apply to arbitration claims. And just quickly, because I will run out of time, that this, I think, does raise the question now of whether we need to update Part 62 to provide for statements of case. Again, I think there must be quite a strong argument for that, so as to provide parties with a mechanism for an orderly way of presenting their written arguments well in advance of any hearing. Okay, so if we just move on to the next slide, and just circling back really to the Law Commission consultation, I've just set out on the slide there the topics that they have identified as possibly meriting further discussion. I'm sure we've all got our own ideas about what needs to be looked at. And could we just go to the final slide now? This is just the link to the consultation. And I really wanted to finish by encouraging anybody with ideas or thoughts about this to participate in the consultation with a view to ensuring that the voices of London maritime arbitration users are heard in this process. Well, that's all that I was going to say today, so I will now hand back to Lord Hamblin to move things on.
Thank you very much, Karen. And I would particularly endorse the last comment you made. It's important that anybody who has views as to how arbitration in the UK may be improved responds to the Law Commission's consultation. These opportunities only come around rarely, maybe once in a generation. And I'm sure the Law Commission would be receptive to all suggestions, not just those in the areas that they've identified. As Karen said, one of those areas is the often debated question of permission to appeal and whether the current regime strikes the right balance. There's no doubt that these days far fewer shipping cases get to the courts as a result of the strict filter of permission to appeal. And this appears to have discouraged applications as reflected in the statistics to which Karen referred. My own experience from the judicial side of the curtain is that if the case raises an arguable issue of law of general importance, then there is usually a reasonably good prospect of getting permission. It's the importance of the point that is often key, as most important points are well arguable and not easily or best dispensed with on the papers. The development of maritime law is a matter which our next speaker is going to address. Nick Austin is a partner in the transportation team in the London office of Reed Smith. He advises a wide range of clients in the shipping industry on resolving maritime and trading disputes in arbitration, mediation, and court proceedings. Nick will highlight what legal developments are emerging from arbitrating shipping disputes in London.
Thank you very much, Lord Hamblin, for the introduction, and a very good morning, afternoon or evening to everyone joining us today. It's a great pleasure to be on today's panel and in such esteemed company as well. For the next 15 minutes or so, I'm fortunate to have an opportunity to offer a few thoughts on English maritime law itself and its relationship with the maritime arbitration process, which we've heard about and which of course applies it. Nothing too heavy for a Friday, I promise. Next slide, please. There's no doubt in my mind that if London Maritime Arbitration is to continue the success it has enjoyed and worked hard to enjoy for so long, then the maritime law which underpins the disputes it hears and which the parties have chosen as their governing law needs to develop continuously. It needs to be regularly reconsidered and restated. It needs constantly to evolve, to reflect commercial practice, or to respond to a broader change in judicial thinking, and of course if it's the right thing to do in any given case. In short, maritime law needs to live and breathe if it's to be relevant, and critically if it wants to serve the commercial community who rely on it for the certainty and consistency and balance which are its intended hallmarks. And of course its impact and influence doesn't end on these shores. Developments in English law are adopted or at least keenly felt in many other jurisdictions with a common law system, and this gives it a global reach to match that of the shipping industry itself. Next slide, please. So that's the place of maritime law. How then does its development happen? Well, we've already heard about the sheer numbers of maritime arbitrations taking place in London. And of course, arbitration awards published confidentially are of enormous value to practitioners and parties resolving their disputes in the industry, adding, as they do, I think, to the analysis and practical application of the law. But the law is mostly made in the courts, which still plays host to dozens of shipping and trade cases each year. Sometimes they go there directly because of the parties' jurisdiction agreement. But I think more of the time they reach the court via arbitration, and in particular LMAA arbitration, as you would expect, on appeal or through one of the mechanisms in the Arbitration Act 96, which enable the court's oversight and involvement in the process. And we've heard about section 45 from Karen already. In short, maritime law could not and would not develop without arbitration. I could have the next slide, please. Happily, for those of us practicing in the maritime sector, shipping law has, by and large, been alive and well for a very long time. It continues to develop and adapt to the world around it, to changes in the patterns and risks of international trade and carriage of goods by sea. And that, of course, speaking personally as well, makes it interesting and varied, but it also makes it dynamic and responsive to external factors and real-world events. So we can genuinely say, it seems to me, that by its very nature, maritime law reflects the state of things on a truly global scale. And it's probably when the world is facing its most pressing challenges and times of change, past and present, that maritime law has been called upon the most, because in a very real way, of course, shipping and trade is directly impacted by global events, be they geopolitical, piracy, sanctions, the trade dispute ongoing between Australia and China, or health-related, the pandemic, of course, or just even the practical, one ship getting stuck in a canal, highlighting our reliance on potentially vulnerable supply routes. Many will say, I think correctly, well, it was ever thus, and I think they're right. The oil crisis in the 1970s, a plethora of grain cases arising from trade embargoes over the years, and of course, numerous conflicts, not least the Iran-Iraq wars of years gone by, have all produced decisions from superior courts, which remain with us today. So for as long as ships continue to move 90% of the world's trade, as they do, English maritime law will, I hope, stay relevant and meet the challenges of the future. Next slide, please. So what do all these disputes look like in today's climate? Well, from a brief review of recent arbitral and court decisions, as I found them, it appears that all the major elements of maritime law are being aired fairly regularly and evenly. issues with charter parties, the withdrawal of vessels from time or bareboat fixtures, hire issues, cargo claims, bill of lading disputes, shipbuilding cases and more. All of these are evident in numbers in the reports. And a very quick review of the LMAA case summaries of this time last year reveals 7 time charter disputes, 8 voyage charter disputes, and 7 others covering procedure and jurisdiction, shipbuilding, and sale and purchase disputes. So a good spread. And from what one can glean from the facts of those cases, they very much hold up a mirror to the impact of global events on shipping and trade. Tomorrow's decisions may start to reflect the impact of the pandemic, as I think they will. Force majeure, delays, additional costs, termination, quarantine, and unfortunately insolvency. But more traditional disputes have continued alongside those new issues. And that's perhaps not surprising, given that shipping has continued unabated during the pandemic in a way that aviation, of course, clearly has not. So what can we say about developments in the law that are emerging from all this? Well, it would obviously be impossible in the last few minutes to summarize all the changes in maritime law that have emerged from London arbitration. Perhaps a good older example of a case that has stood the test of time is the Law Prima on the effect of the reachable on arrival provision in the As-per-Tank Voy Charter. A case that was started in arbitration, was reversed at every stage of appeal, right up to the House of Lords, with their lordships eventually siding with the High Court, and not the arbitrators with whom the Court of Appeal had agreed. But that's still 2 tribunals each, and it remains a decision of relevance and impact to this day arising from arbitration. But what I want to briefly illustrate by reference to 2 recent cases is how London arbitration contributes to the development and restatement of some key principles of maritime law. The first, the tie prize, is a really good example of a review by the Court of Appeal of some fundamental and long-established principles involving the master's duty when it comes to signing bills of lading. That arose from an arbitration, and I think renewed clarity and freshness of expression of older principles can be just as important as wholly new developments, whether you agree with them or not. The second is the eternal bliss, a paradigm example of a new development, achieved not through appeal, but as Karen has said, through the, some say, underused mechanism of Section 45 of the Arbitration Act. Next slide, please. So very briefly, looking at the tie prize, a case many of you will be aware of, it's gained a lot of attention. It was a decision of the Court of Appeal following an appeal from an arbitration award. Very briefly, there was a carriage of soybeans from Brazil to China, clean bill of lading presented by the shippers, signed by the master. Damage was discovered on arrival at the discharge port, and the owner settled a resulting cargo claim from the receivers. The owner, in short, the owner then claimed an indemnity from their charterers on the basis that the shippers, who were the charterers' agents, had warranted, they promised, the accuracy of the statements in the bill of lading when they presented it to the master, and which had made it a clean bill, when in fact the cargo was damaged on shipment, but in a way not apparent to the master on a reasonable examination. Next slide, please. At arbitration, the tribunal found that there was a breach of an implied warranty, and charterers were liable to indemnify owners for the cargo settlement because the shippers, their agents, had misrepresented, the condition of the cargo. The High Court and Court of Appeal reversed that decision. They agreed with each other, and they said that presenting a draft bill of lading to the master was merely an invitation to the master to make his own representations based on a reasonable assessment, that being consistent with his duty under the Hague-Visby rules. No damage was visible on loading, and in the circumstances of the case, the shippers made no representations to the owners, and so did not misrepresent the condition of the cargo. Now, the judgment goes into some detail on this key area of maritime law and is certainly worth a read. But for today's purposes, its importance is clear. It's a recent restatement and fresh expression by the Court of Appeal of some pretty fundamental principles regarding the long-established duties of a master. an absolutely central part of the business of shipping, and all arising from arbitration. It's not without its practical difficulties, I should say, as others have, and press reports just today suggest it may be on its way to the Supreme Court. So it may not be the end of the story yet. Next slide, please. The second case, the Eternal Bliss, has also attracted a fair amount of attention since judgment in the Commercial Court last September. And I must declare an interest at the outset here, given that I represent the owners. But the case addresses an important question and never conclusively settled, which is this: if the owners incur additional losses waiting at ports, and those losses are unrelated to the vessel's detention, in other words, its earning potential lost through time, must they show a separate breach of charter causing that loss to recover it? Or can they recover it simply on the basis that the charter has exceeded the lay time? It had been thought by many that the answer to that question was yes. In other words, it was not enough to say that the additional loss had been caused by the expiry of lay time, because demurrage was the only remedy for any type of loss caused by that breach of exceeding lay time. That was all you got. So to recover anything else on top, you needed to show that separate breach. In the Eternal Bliss, the parties to an arbitration agreed, jumping through at least one of the hoops mentioned by Karen, to refer this question to the court under that Section 45 mechanism. And a really interesting part of the judgment is quoted here on the slide by Mr. Justice Andrew Baker. And I won't read it out, but you can see that in a nutshell, that shows the emergence of law from arbitration, the clarification of a point of long-standing uncertainty for the benefit of all. Very briefly, what happened? Well, it's another soybean case. Cargo damage was caused by 31 days of waiting at the discharge port after tender of the NOR and lay time starting. And the owners settled a claim at from the receivers, sought an indemnity from voyage charterers for the failure to discharge within the lay time. Those were assumed facts for the purposes of the question. Next slide, please. The questions that the court was asked to look at were these: can an owner recover damages in addition to demurrage for losses caused by the charterer's failure to discharge within lay time without showing a separate breach? And allied to that, what is demurrage intended to compensate? Next slide, please. The court found that there was no requirement in quite a thorough judgment. There was no requirement to show a separate breach of the charter to recover losses of a different type to delay if those losses had been caused by a failure to discharge within lay time. Demurrage on that topic liquidates, the court said, damages for detention of the vessel as a freight earning asset. It, quotes, does not seek to measure or therefore touch any claim for different types of loss. So the court said, contrary to the view of many, including some of the leading textbooks, that the owners could recover additional losses beyond demurrage for other types of loss caused by the failure to complete discharging within lay time. You do not need to show a separate breach because demurrage only fixes losses for detention. Final slide, please. So here again, under the Eternal Bliss, a decision of real importance and impact to the industry, and again from arbitration, but not this time by way of appeal. It has for now clarified a question debated since at least 1927, a case called Reader and Arcos, but the Court of Appeal will hear the case in October of this year, so a further review will be taking place then. So to sum up, what I've tried to demonstrate and hope to have demonstrated with two recent but I think important decisions is that English maritime law continues to develop and emerge from London maritime arbitration on a regular basis, and more generally to show that the points of law emerging from that arbitration are wide-ranging, testament I think to the breadth of disputes in the industry referred to arbitration, themselves reflecting the state of the market and the world around us. That was all I was going to say, Lord Hamblin, so thank you indeed, and back to you.
Thank you very much, Nick. We will have to see if any of the cases you mentioned make it up to the Supreme Court. In relation to maritime and arbitration law developments, as far as the Supreme Court is concerned, in the last year, we had the first collision case to get to the highest court for nearly 50 years, the Evergreen case, and we're shortly to hear the first seaworthiness case for many years, the CMA CGM Libra. We've also had some important arbitration cases, Halliburton, which Karen mentioned, and also ENCA, which concerned the proper law of arbitration agreements. That was a case which proceeded from trial in the Commercial Court in December 2020, through the Court of Appeal and to the Supreme Court for hearing in July 2021 in 7 months. It shows how the courts can act very quickly in urgent and important commercial cases. It illustrates that there's no need for particular concern in terms of delay if an arbitration appeal gets to the courts. The Commercial Court gives priority to arbitration appeals, and the Court of Appeal seeks to deal with commercial cases promptly, as does the Supreme Court. Our next speaker is Jean Coe, who's a partner in the shipping team at HFW and is the head of the dry shipping practice in London. Jean specialises in maritime litigation, focusing on contractual disputes and disputes arising from casualties, including one of the biggest container collapse and overboard losses in maritime industry in recent months. Her topic today is cargo misdelivery claims, and she will look at the various stakeholders' competing interests in these claims and how they play out in dispute resolution.
Thank you, Lord Hamblin, for the introduction, and warm greetings to all who are attending this webinar today or watching this in the future. When I was deciding on a topic for today's webinar, I looked at the cases I was handling at that time, and at least 3 of them involved misdelivery claims running into the millions. So I thought this might be a good topic. Within the last year to 18 months, there have been numerous such claims, mostly arising from a collapse of big charterers and commodity traders. For example, Hinleong, Agritrade, Phoenix Global in Dubai, and their insolvencies, and sometimes involving fraudulent activities. The most common scenario for misdelivery claims is when cargo is delivered to party A without original bills against a letter of indemnity, and then the originals turn up later in the hands of party B, usually a bank. The other scenario is when cargo is delivered to party A against what turns out to be a forged bill, and then party B presents the real original bill to the ship owner. Our focus today is on the first scenario. So it's the original bills turning up after discharge has been made against a letter of indemnity, and we'll look at the stakeholders involved and the issues they face. Next slide, please. Now, this is a typical scenario giving rise to a misdelivery claim and the various stakeholders and contracts involved. Starting with the sale contracts in the green, we have a contract of sale between the shipper as seller of the cargo and the charterer or the subcharterer, and then a further sale contract between the charterer as sellers with a receiver. Payments under these sale contracts are usually by way of letters of credit or payment against documents, and the charterer will usually have entered into a financing agreement with their bank to finance the trades. So that's the brown line. To fulfill the shipping obligation of the sale contracts, the charterer or the subcharterer charters the vessel from the ship owner. So there will be a chain of charter parties represented by the black line. When the cargo is shipped on board the vessel, the ship owner issues original bills represented by the red lines and releases them to the shipper. To get payment, the shipper will present the original bills to their bank, who will then release the same on payment from the charterer's financing bank. So if you follow the red line, the bank then holds the original bills as security or pledge for the loan finance to the charterer. In the meantime, the cargo has reached its destination port and the receiver requests delivery of cargo without original bills. This same request is passed up the charter chain together with the provision of letters of indemnity represented by the blue line. The ship owner then delivers the cargo to the receiver without original bills, but against a letter of indemnity. Some months later, the bank has not been paid by the charterer under their financing agreement and makes a claim against the ship owner on the basis of the original bills that they hold. Next slide, please. So from the claimant's perspective, possession of original bills is king. It gives you title to sue as a lawful holder of the bill under COGSA, or the Carriage of Goods by Sea Act. As the lawful holder of original bills, the claimant, in our scenario the bank, is entitled to delivery of the cargo. The ship owner has strict obligations to deliver cargo only against original bills, and they will be in breach if they deliver without presentation of originals, unless of course the contract says otherwise. So even in the event of fraud by a third party, for example, if the ship owner delivers against forged bills, and even if innocently, they will still be in breach. The bank can also claim in tort for conversion. To make this claim, the bank will have to show that they have an immediate right to possession of the goods at least. So this is typically evidenced by the possession of original bills which have been transferred and endorsed to them. So it's a relatively straightforward claim to make. However, the governing law applicable to such a claim may not be English law, but the law which is more closely connected to the performance of the obligations. For example, the law of the jurisdiction where the tort occurred, which could be where the cargo was misdelivered. This means the law and jurisdiction for the tort claim may not necessarily be the same as the contractual claim. So in practice, although a claimant will always formulate their claims in both contract and tort, the focus is usually on the contractual claim. Next slide, please. So moving on to the ship owner's perspective. Of course, the ship owner's first instinct will be to defend the claim. Unfortunately, there are only limited ways to defeat a misdelivery claim, and it very much depends on the facts. The first obvious one is to ascertain whether the bills which the bank holds are genuine. If the bank's bills are in fact forged, then all the bank has is a piece of paper which looks like a bill of lading, and they have no claim. If the bank's bills are genuine, depending on the facts, the ship owner can try to attack the bank's title to sue. Under Section 5 of COGSA, the requirements of a lawful bill of lading holder are endorsement of bill of lading to the claimant, completion by delivery of the bill to the claimant, and good faith. There are usually no issues with endorsement and delivery of the bills. As for good faith, in a Singapore case, the UAO, the court can find this to mean dishonest conduct, which is rare, and will therefore be difficult to rely on. Whether or not the English courts will give a broader interpretation to the meaning of good faith in this context remains to be seen. Case law also suggests that to be a lawful holder of the bill, there must be an intention on both the endorser and the endorsee, which is the bank, that the endorsee would be the holder of the bill. So, for example, if a bank is holding original bills purely as floating security over the charter's loans or financing arrangements, which is not specific to the particular misdelivered shipment, we can perhaps argue that there was no intention between the charterer and the bank that the bank should become the lawful holders of the bill. Something to think about. Another argument which the shipowner may have against the bank is if the bills were already spent by the time the bank took possession. For example, if the cargo had already been delivered to receiver before the bank came into possession of the bills. This argument has been tried in a number of cases, but have mostly failed, primarily because it was not proven that the bills were spent. In order for a bill to be spent, it is not sufficient just to show that the cargo has been delivered. It must be shown that the cargo was delivered to a person entitled under the bill. There are some very complicated issues in relation to this point, but I'm afraid there is no time to discuss them here, but I'll be happy to discuss them privately with anyone who is interested. Finally, linked to the good faith argument, if it can be shown that the bank had consented or agreed to delivery of cargo without presentation of original bills, the owner may have better chances to defeat the claim. In the case of the NICA, the bank had agreed a scheme with their customer, who were the charterers, that the cargo would be discharged without production of original bills, and that the cargo would be transferred to a bonded warehouse. The original bills will then be used as keys to unlock the bonded warehouse, but not as keys to unlock a delivery from the vessel. In light of that scheme, the court held that the bank had no arguable case for misdelivery against the shipowner. I think this must be one of the few cases where a shipowner has successfully defeated a misdelivery claim from a bank, but obviously that requires a lot of information, fact-finding as to what's happening between the bank and their customer. Next slide, please. Given the odds which are stacked against the shipowner, in parallel with defending a claim, the shipowner will want to look at recourse options. The most obvious channel would be against the charterers, either for an indemnity under the charter party for complying with charterers' orders, or more straightforward, under the letter of indemnity issued by the charterers. The LOI is a separate and independent contract to the charter party, and any claim under it will depend on its wording, although these days they are more or less in standard IG wording. The key factual point which the shipowner has to prove is that they have delivered the cargo in accordance with instructions in the LOI and to the correct party. If the shipowner can prove that, then there is little question that charterers must indemnify the shipowner. It's all very well if the charterers are financially sound, but if the charterers have no assets or have gone into insolvency or are the very party which caused the misdelivery claim, then the LOI claim against the charterers is of little use. In those circumstances, if there is a subcharterer down the line, it might be possible to have a direct action against them under the LOI that the subcharterer has issued, if the LOI is also addressed to the owners, disponent owners, charterers, and the terms of the indemnity extend to cover the servants and agents of the charterers, which would include the owners. Another possibility is a claim against the cargo receiver who took delivery of the cargo without presenting original bills. If the receivers issued a letter of indemnity, there could be a direct claim under the LOI. Otherwise, the action would be in conversion. Such actions would inevitably have to be pursued in the jurisdiction where the receiver is based and will be subject to local law. The more interesting question for me, however, is whether the shipowner also has a claim in contract under the bill of lading against the receiver. I question this because the receiver never came into possession of the original bills and may not have been intended to ever receive the bills. I think this will depend on whether or not the receiver claimed delivery of the cargo based on their alleged entitlement under the bill, but that is another point for us to ponder over. Next slide, please. So looking briefly from the charterer's perspective, as already mentioned, if owners can show that they have complied with the delivery orders in the LOI, charterers will be liable to indemnify them. And if owner's vessel is arrested by the bank, the LOI terms usually require charterers to provide security directly to the bank to lift the arrest. If charterers do not provide security, the owners can apply for a court injunction compelling them to do so. Now, this will be the case even if no LOI was physically issued, if the charter party contains a clause requiring charterers to indemnify the owners. And this was confirmed in the Miracle Hope number 2. When faced with such a claim from owners, if there is a subcharterer down the line, charterers can look to their subcharterers for an indemnity under the LOI provided by them. And following the Miracle Hope number 2, they can also require their subcharterers to provide security directly to the bank in order to secure the vessel's release from arrest. And then my final slide, please. So to pay or not to pay, that is the question. For the ship owners out there, I'm afraid to say a misdelivery claim from the bank is a big headache. If the bank holds the real original bills, you are very much starting on the back foot, and these claims are difficult to defend, and case law tend to be favorable to the bank's position. You can also face numerous misdelivery claims arising from just one shipment or even one bill of lading, depending on the magnitude of the fraud involved. And you might be at risk of losing your vessel if there are numerous claims. If you're lucky, you will have a good and financially sound charterer or subcharterer to indemnify you for your exposure to the bank. I'm often asked by ship owners how they can protect themselves in these situations or how they can prevent such claims. Realistically, it's not commercially possible for them to refuse to deliver cargo without original bills. So I think it comes down to careful chartering, making sure you have good indemnity provision in your charter party. Also, the LOI is only as good as the party providing it. And so if it is possible, you can try to fortify it by asking for the LOI to be countersigned by your charterer's parent company, if there is one, by the receiver, or even by a bank. Well, we live in hope. On that note, I hand back to Lord Handlin.
Thank you very much, Jean, for that summary and those insights. Misdelivery claims have given rise to many claims over the years, and it would seem from your talk as if they will continue to do so. We're running slightly behind time, but we may go a little bit beyond 2 o'clock in order to take questions. And we're now going to go into a gallery view for the question and answer session. We've received a number of questions in the run up to the webinar and during the webinar, and Jonathan has been screening them and will now read those shortlisted aloud so I can direct them to the panel or ask a particular person to respond or a volunteer to respond.
Thank you, Lord Hamlin, and thank you for staying with us possibly after 2 o'clock for 10 minutes or so. Here's a question which I think will probably go to Karen or Ian Gaunt in your discretion, sir, or both. Do you think the LMAA should amend its terms to clarify the practice as identified in Halliburton?
Well, I think I'll ask that Ian that first of all.
First of all, I should say that anything I say about this is from my own view and not an LMAA view as such. I think, as you've heard, the LMAA is actively looking at this at the moment, but it raises some quite intricate problems in terms of what the reaction to Halliburton ought to be. Certainly, maritime claims pose some rather different issues to typical international commercial arbitration cases. We would have to, if we make changes, do things which will cater for the typical type of chain arbitrations which are common in both LMAA arbitrations and also GAFTA arbitrations, and which were the subject of some of the submissions in the Supreme Court. We would perhaps have to do something to deal with cargo claims, many of which arise out of the same incident, but where the same arbitrator is appointed, and other things of that kind. So I can only say that it's under active consideration at the moment. It's apart from the terms themselves, which have in fact only just been changed, it's perhaps more likely that a change, if it's to be made, will be made to the code of ethics of the LMAA arbitrators, which are available, publicly available. To some extent, they already follow some aspects of the IBA guidelines on conflict of interest, but it's something which we're keeping under close review at the moment, and there are different views as to whether changes should be made and indeed what changes would be appropriate.
Right, maybe the next question, Jonathan, I think.
Okay, I think this one is directed to Nick Austin. You talked about the type of issues faced by the shipping industry during the COVID pandemic. Have you started to see any legal developments emerging from those issues?
Yes, I'll answer that. I mean, the short answer is yes, but not in great numbers yet. I mean, there's no doubt that the pandemic's had a profound impact on the industry and on all of us, and led to disputes. But of course, the prevalence of arbitration in resolving them, and then the time it takes for those disputes to feed through to the courts, mean that they haven't gone through the system yet to be reported. There has been one, again widely reported, I think in January of this year. The Admiralty Court handed down a judgment dealing with the P&O vessel, the Columbus and the Vasco da Gama, if I get the names right, and that arose out of insolvency, but actually the impact the pandemic on the cruise industry, which of course has been severe.
Mm.
So that is one example. There may be a couple of others out there, but I think over time we will really see more pandemic-related cases coming through, as I say, as they get through arbitration and emerge on the other side and through to the court process.
Thank you. Jonathan.
So, what about this one? If there are several banks all claiming to hold the original bills of lading for a particular cargo, how does the ship owner know which bank to pay?
That's probably for Jean, I think.
I was just about to say, well, with difficulty is the answer. I think given that the point is to know which one is the genuine one, you'll have to physically inspect all the various bills of lading that the banks are saying that they hold, and forensic examination experts would be necessary. In fact, in one of my cases, we attended the bank's office and physically inspected the alleged original bills. And when we touched it, there wasn't an imprint for the signed endorsement on the other side, and that suggested that the bill was a copy. They were very good copies. So I think the first point is basically to ascertain which one is the genuine one, and then you can use that to defend the other claims. But with the ones with the bank who's holding on to the genuine one, then obviously all the defenses that I've discussed in my little talk would apply, depending on the facts.
Thank you very much, Jean. Jonathan, have you got a question that might steer towards Karen?
Yeah, absolutely. I was just looking at one here. In relation to future provisions, what would be the most valuable, important amendment to the Arbitration Act? So the Act itself, nothing to do with LMAA terms or anything like that. What would be the most, in your view, important amendment to the Arbitration Act?
I think there's one that would be a really easy win, and it's one of the ones I identified in my talk, and it's making some amendments to Section 44. I think in a sense it's a bit of a no-brainer, because the intention behind Section 44, and it actually says this in Section 44, is that the court is supposed to have the same powers as it has in court litigation. And unfortunately, due to the way that the detailed provisions are worded, we found ourselves in a position where that's not the case. And I think that's important, because one of the reasons, as I perceive it, that London Maritime Arbitration is very popular is that there is strong support from the commercial court and higher courts. And so being able to go and get a freezing injunction in appropriate cases is very much valued by users of arbitration. So I think I would see that as really an easy win, and one that could be effected without too much difficulty or knock-on sort of complexity. So I think that's the one that I would identify.
Thank you, Karen. I think, Jonathan, one more question.
Okay, thank you, sir. A question, I've combined two questions here, just and see where we get with it. While the LMAA enjoys a well-deserved reputation for the determination of international shipping disputes, it does have competition, both in terms of the type of arbitration procedure followed and geographically. So two parts to this question. Why do parties in the maritime field prefer ad hoc arbitrations a la LMAA to institutional arbitrations, would be the first part. And secondly, as regards geographic rivals to London, why should an owner and a charterer include a London arbitration clause in preference, say, to SCMA, Singapore arbitration, or indeed SMA across in New York or Hong Kong?
Well, that's quite a lot of questions, but I think that's for you, Ian.
Well, I'll try to give the short answer rather than the long one to this. First of all, as far as ad hoc arbitration is concerned, I think what you see in maritime arbitration is that it works on an ad hoc basis because there is a very high level of trust in the experience of the arbitrators. The main difference between an ad hoc arbitration and an institutional arbitration is it's the arbitrators, the tribunal, who run the arbitration, and they have the experience to do so. The parties are really confident in that, and they don't therefore need an institution standing in the background to keep the arbitration on the right track, as it were, whether in terms of deadlines or in terms of administrative support. There are some functions which an institution can help with, and sometimes we might encourage parties, for example, to use the LCIA to keep security deposits or things of that kind. But overall, the flexibility which is available from ad hoc arbitration is much, much greater. And I must say that my own experience of sitting as an arbitrator, both in LMAA proceedings and ICC proceedings, if I can contrast those two, is that the parties are very, very much better served in maritime cases, at any rate, by LMAA arbitration. I found that some institutional arbitration, some of the secretariats can be really extremely heavy-handed, to the point even of trying to rewrite the award, which is written by perfectly competent arbitrators. As far as the second point is concerned, yes, we do have geographical competition. Perhaps the closest competitor at the moment is Singapore, which has a new case load as of 2020, which runs less than 10% of that of the LMAA, if you count both SCMA and SAIC together. But I think what is important in this context is that English law is quite clearly the lex franca of the maritime world, and parties may have an interest in going to other arbitration centres for various reasons. But if they want a decision on English law, and as long as English law remains that lex franca of the maritime world, then they're better doing that through an arbitration in London, where there is a right of appeal to the English court and to English judges who are the ultimate arbiters, or should be the ultimate arbiters, of English law. And other forms of law which have marketed themselves in the maritime space, and I would again mention Singapore, do not seem to have had the buy-in that English law has traditionally had and seems to continue to have, so that one does see mixed forms of law and arbitration clauses in charter parties sometimes, which would say English law, Singapore arbitration. But remember, there is no right of appeal in Singapore on the point of law, so you're not going to get a decision on that point of English law from the Singapore courts, or indeed anywhere else, if you adopt that practice. So you need to be very careful. It's very easy for brokers to adopt a sort of hybrid arbitration clause of that kind, but they need really to understand the consequences of doing that. And my suggestion would be that the best place to litigate or arbitrate on English law is England. Thank you.
Well, thank you very much, Ian. I'm afraid that's all we have time for. We've had attendees from all over the world, some 40 countries, and I'd like to thank you all for attending. Thank you also to our speakers, Ian Gaunt, Karen Maxwell, Nick Austin, and Jean Coe, for their excellent presentations. And I'd also like to thank Jonathan Webb and HFW for hosting the webinar, and I'll now hand back to Jonathan to close.
Thank you very much, Lord Hamlin. It's been a very interesting session covering maritime arbitration in London with present and future challenges in our changing world, and delighted to be a part of LIDW 21 and to have worked so well with our fellow consortium members on this, who Lord Hamlin has already thanked. I'd also like to thank Lord Hamlin for making time. It's not often that we get an actual serving Supreme Court Justice to chair one of these things. Hugely busy schedule, and we greatly appreciate that. I thought your brief but astute comments throughout the webinar reminded one of the clarity and insight you brought to so many judgments, including in my personal favorite was restoring sanity, in my view, in sparse shipping, when you confirmed that payment of hire was not a condition, but a very strictly construed innominate term. Anyway, thank you very much, sir. Thank you to the panelists. Thank you to the LIDW. Thank you to my team at HFW who've done a brilliant job behind the scenes, and indeed the backup teams at Reed Smith, 20 Essex, and the LMAA. And that's it really. I just two announcements. Don't cut me off yet. Oh no, don't cut me off yet, please. Slides will be circulated. Slides and a recording will be circulated. So don't. Some of you have been asking about that. You all participants will get that, and we will also be seeking some feedback from those of you who have participated in this call. And I think with that, we're going to pull the plug. It's it.
Thank you.